Hi, I'm Douglas Guilfoyle and I'm here to introduce international criminal law at University College London. So in 1945, at the opening of the Nuremberg trials, Justice John H. Jackson talked about the trials as being the greatest tribute power has ever paid to reason. And what he was drawing attention to there was the idea that at the end of a major conflict, the victorious powers, as he put it, flushed with victory, would put their opponents in the dock and submit them to judgment under international law rather than simply summarily detain, exile or execute them. And that legacy, I think, has really stayed with how we approach international criminal law, the idea that you can put high leaders on trial for serious crimes. But of course, international law after Nuremberg, or international criminal law, really slept for about 50 years until we saw the UN Security Council create the international tribunals for the former Yugoslavia and Rwanda to deal with specific conflicts and specific atrocities. And that revived interest, of course, led to what we have now, the Permanent International Criminal Court. So what we saw in the 1990s after the 1940s was this rebirth of an idealism about what international law could do about atrocities and major conflicts. And we've now seen the International Criminal Court run for 10 years as an active operating institution, and we've also seen the tribunals for Yugoslavia and Rwanda begin to bring their work to a close. And now new questions are arising about whether that idealism was totally justified and about whether international criminal law can really do all the things that we expect it to do in a post-conflict society. It's very common to say that there can be no peace without justice now, but is that entirely right? Sometimes maybe peace has to come before justice. Also, international criminal law promises an awful lot to victims, and the question is whether it always delivers on those promises. So it's a very interesting and wide-ranging course, but it's also quite a challenging one, because international criminal law, in a sense, is a hybrid discipline. It stands at the intersection of a number of related concerns. You need to bring to it the kind of concepts you've learnt in studying criminal law at a national level, concepts like mens rea or guilty mental state and prohibited acts. It also draws on the law of armed conflict, particularly in the field of war crimes, and of course on human rights law. And all of these different bodies of law have, as it were, different priorities, different concerns. Human rights law, for example, is obviously about the protection of potential victims of abuses, whereas criminal law places a very strong emphasis on the protection of the rights of a defendant. And in an international criminal trial, those different concerns can come into tension. So it's an interesting course, but sometimes a challenging course. And the other thing that we'll bring into it is the fact that if it's ever going to work, most prosecutions will have to be conducted by national courts. And that brings into play other concerns, because international law historically has been very keen on giving significant immunities to foreign officials and in respect of conduct performed in other countries. And that can impact on the ability to have international criminal law trials in a national jurisdiction. So that's broadly what we'll be looking at in the course. Who's teaching it? Well, me, obviously, Douglas Guilfoyle, and you'll also be taught by Professor Roger O'Keefe, who's a long-standing specialist in the field. And the way we'll teach the course is really a mixture of styles. There'll be both a degree of conventional lecturing when the material is heavy and needs an introduction, but also there'll be a strong emphasis on seminar-style discussion where you're expected to have done the reading ahead of time and come to class prepared to discuss it and to engage with your peers in that discussion. And finally, we include in the course an International Criminal Court moot simulation. So over 2 classes, you will participate in a simulated and highly simplified trial at the International Criminal Court. I say simplified for the simple reason that we don't have 5 to 10 years to run the trial. We've only got 2 two-hour sessions. So how do we structure the course? Broadly, it can be divided into a number of themes. And the first one, I'd say, is the history and objectives of international criminal law. It's very difficult to understand the case law and its development unless we spend a bit of time looking at the institutions that have helped generate it, particularly international criminal tribunals. So the major ones there are the Nuremberg Military Tribunal, the International Military Tribunal at the close of the Second World War, the international criminal tribunals for the former Yugoslavia and Rwanda, as I've mentioned, and the International Criminal Court. And we spend quite a bit of time on the International Criminal Court. But also in that sort of first block, we spend some time considering, well, what are the objectives of international criminal law? At least one commentator has suggested that there is an overabundance of goals that we are trying to achieve through international criminal law, and it's hard to work out whether something is a success or a failure unless we have some idea of what we think it's there to do. Then the next major block in the course is usually what we refer to as the core crimes. Interestingly, there's not really a particularly clear-cut definition of which crimes should count as international crimes. So we normally wind up looking functionally at those crimes that are within the jurisdiction of international criminal tribunals. And these are crimes against humanity, genocide, war crimes, and the crime of aggression, that is, the crime of aggressive war. And we'll go through the history of those offences and also, obviously, their technical requirements. But one interesting thing to note, even at this stage, is our perception of which are the most serious crimes has changed significantly over time. The Nuremberg judgment did not mention the word genocide, and there the principal crime was the crime of aggression. Now it's the crime least likely to be prosecuted before an international tribunal, and we're used to thinking, perhaps incorrectly, of genocide being the main international crime. Then at the margins, as it were, of those core crimes, we will consider a couple of transnational crimes, crimes that can be prosecuted in whichever state wishes to take jurisdiction, principally offences of terrorism and torture as defined under specific treaties. Another significant block of topics that we'll cover is what I'd call general principles of liability. So it's not just enough, obviously, to define a crime. We have to have rules that allow us to understand who has committed the crime. So one of the big issues here is modes of participation. How do we connect? Typically, defendants in international criminal trials are high leaders. So how do we connect them? How do we connect their conduct with crimes often committed far away and by different people, foot soldiers, if you will? What theories as lawyers allow us to say this person in this office is responsible for these events on the ground? And the answer is not always as straightforward as you might think. Also then there's the question of, well, what do you have to have known or intended? What's the relevant mental state for the commission of an international crime? And finally, what are the circumstances that might exclude criminal responsibility? What are the available defences or justifications for conduct? So we tend to say that the Nuremberg defence has been abolished, and what we're talking about there is superior orders, but actually almost every international criminal justice system recognises to some extent a defence of superior orders. But what are its limits? For what crimes is it available? So those are all things that we'll cover in what we might call the general part of international criminal law. General in the sense that it applies across all the crimes. But then, as I've already mentioned, if international criminal law is going to be truly effective, it will often have to be prosecuted before national courts, and that raises questions of both jurisdiction. When do national courts have the ability to prosecute particularly foreign nationals for offences conducted abroad? And immunities. Is it still possible for heads of state or former government ministers to plead that they have immunity from criminal prosecution in a foreign state, even for an international crime? And there the answer is more complicated than your first impressions may be. And that brings us to the centrepiece of the course, even though it comes at the end rather than the centre, which is the two classes we'll spend conducting a international criminal court simulation moot. The class will be divided into groups and will take a role in one of the two sessions. And the two sessions include both an admissibility phase before the court, so is this a case that the court can hear, and then a merits phase where we look at both the crime and relevant crimes and their elements and how they might be applied in a courtroom setting. The final topic that you're probably interested then in is how the course will be assessed. And the structure of assessment we have is that there will be a 3,000 word essay allowing you to go into detail on one of the topics covered in the course, and a 2-hour exam in which you'll be expected to demonstrate a general knowledge of the course more widely. And there'll be what we call here formative assessment for both of those. That is, you'll get to submit part of your research essay for comment, around 1,500 words, and also do a mock exam answer. So you have some idea of what we expect from you over the course. So in a nutshell, that's international criminal law as we teach it at UCL, and I hope very much to see you in class.